Hi, my name is Rachel Buss, and I'm the Managing Attorney at the Law Offices of Brelje & Associates. Thank you for watching this week's edition of the Brelje Immigration Brief. In this past week, there's been a lot of attention paid to the subject of birthright citizenship, and so we wanted to give you some more information on that topic. To understand birthright citizenship, we have to delve into a little bit of a U.S. history lesson, so please bear with me. When the Constitution was first ratified in 1788, there was no definition of U.S. citizenship included in the Constitution, and so citizenship would have been understood through British common law at the time. In an attempt to define who could acquire U.S. citizenship, Congress passed acts in 1790 and 1795 declaring that only free white persons of good moral character could become U.S. citizens. Now, these laws were challenged in 1857 when an enslaved man named Dred Scott sued for the right to his own freedom. His case made its way to the Supreme Court, and in its decision, the Supreme Court stated that slaves and their descendants were, quoting, so far inferior that they had no rights which the white man was bound to respect. In other words, at that time, U.S. citizenship and the right to it was divided by race. Some historians point to this decision in the Dred Scott case as accelerating the U.S. Civil War. So in the aftermath of the Civil War, the U.S. ratified the 14th Amendment, which states, quoting, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So the legal term for this type of birthright citizenship is jus soli, or right of the soil, and it has a long history in English common law. This is contrasted with jus sanguinis, or citizenship inherited from a parent, and citizenship by birth is conferred upon anyone born within that country's jurisdiction. So in the 1880s, there were a series of laws referred to as the Chinese Exclusion Act. And these laws prohibited the immigration of Chinese laborers to the United States. So in 1895, a man named Wong Kim Ark was denied re-entry to the United States after returning from a trip to China. The customs officials claimed that he was not a U.S. citizen in spite of the fact that he was born in San Francisco because his parents were Chinese citizens and were permanent residents in the United States. So the case made its way to the U.S. Supreme Court, and in a 6-2 decision, the Supreme Court concluded that the language of the 14th Amendment grants U.S. citizenship to the children born in the United States to foreign parents, with a couple of exceptions. The exceptions they identified would be children born to diplomats and any children of conquering forces who happen to be occupying territory in the United States. So the right to U.S. citizenship for nearly all people born in the United States has been enshrined in the U.S. Constitution, and it would likely take another constitutional amendment in order to alter or do away with birthright citizenship. If you have any questions for us, please visit our website at www.brelgelaw.com. Thank you.